I just want to mention a REIT application. Due to the pendency of this REIT application, as a widow, I am suffering from financial crisis. Honorable
Maintenance.
Yes, Lordship.
Maintenance or what? REIT? What?
Fixed deposit has been blocked, my Lordship, from the bank.
What has been dropped?
A fixed deposit.
Under which law you are?
Seized my fixed deposit of mine.
Under which law?
Lordship, there is a pendency of the cases on the bank.
Under which law? They have seized.
They are seized from due to some inaction of interaction.
All right, you give the
Let us see.
Pardon to mention, my lord, I am from the petitioners are poor marginal farmers seeking issuance of paddy card, farmer card for issue of for sale of their paddy at the MSP rates, my lord. Last year they were given, but this year the Tahsildar is not taking any action, my lord. Odisha Paddy Procurement Rules 1982.
Pardon to mention, my lord,
Obligation.
fresh rate application, my lord. The petitioner has applicant has filed this rate appeal challenging the order of the honorable single judge, my lord. Petitioner.
The parliament and the panchayat around out of 12 ward members, 8 have been disqualified by the collector because of political compulsion. This matter was heard before the assignment, the change of assignment to my Lord Justice R.K. Patna, and it was specifically adjourned to 22nd. I have been mentioning before Honorable Single Judge, who has been assigned now a place. He has expressed his inability to pick up the matter. But this urgency is out of entire panchayat is reformed. Any after notice matter of 2025, irrespective of agency. Yesterday I had mentioned and he expressed that you go and mention before others. Court number 1. Please.
Madam, item number 21. Last occasion, your lordship said that I direction that amendment the prayer, but Mr. Dole is out of session. No?
Maybe, pardon to mention, my lord, matter relating to approval and the sanction of granting net, which is pending since 2013. Whereas other employees have, my lord, single mess matter, rate of it. Yes, my lord. Also, single
Restitution matter.
my lord, another is rate of it. Sanction of area and other.
Madam, lordship, this matter is
Inform the other side that you have mentioned.
Madam Lordship, this is a matter challenging the disqualification of appellant. He is a sarpanch. He has been disqualified under section 20. Yes. Yes. My lord, yesterday this matter was kept adding the activity showing that the victim girl is major. That is reserved. We are fine.
You can't produce some documents for the first time and appeal when the matter has already been resolved. After all, we are hearing an appeal.
Okay, that
Can we
document,
do it.
my lord,
First time.
my lord, that document is annexed to the writ application. But we are showing our benevolence by filing.
Of humility and the respect. Mentioning unilaterally without the other side. Without giving an opportunity, what you want to say is not proper. So you should have given a notice to the other side that you are going to mention this matter. You wanted to mention certain facts. So that he may not be put on surprise. If we take into consideration, then he will say that I was not aware that something has been given to me.
A copy of the same.
Sorry, this can't.
Listen. You cannot add a new document.
Right, new document, no new
So
document.
if all the document is already on
On the
record, then you will not supply this copy. Keep it on.
For the better clarification.
It's not.
And also made
Not required,
at the time of we was.
Sir, then order 41 rule 27 is applicable. Can you do it in additional evidence in this regard?
No.
Then how can you do it? Appeal has a limitations. You can't do it.
That document is annexed to it.
Or let me consider it, don't worry, don't inculcate a sense that we will not take into account any document. Don't worry. Let the judgment come and we can say,
21.
what do you want?
Last time next week.
Yes,
Next week,
where is the other side?
state.
State means who is appearing in 21? You are appearing? Yes. He is asking for a time. What do you say? Really?
This admission item number 1. May it please, my lords, I beg to appear, my lords, for the petitioner in this matter.
I'm sorry, Your Lordship, the copy of the repetition has not been served to me, Your Lordship. When I'm the answering party, Your Lordship, the copy of the repetition.
Has not been served. What are you doing, sir? Why don't you serve the copy beforehand?
My lords, apologies, my lords, I'll, my lords, immediately serve the copy, my lords. All I'm requesting, my lords, is, my lords, the issue here, my lords, has already.
Sir, you can't take advantage of the, the inconvenience of the other side. He's not holding the brief.
Very well, my lords. My lords, no difficulty, my lords. I will serve the copy and my lords, my lordship.
Of this day, serve the copy in course of this day. Matter will be listed in the next week.
Very well, my lords. Lordships, can it be a specific date, my lords, if your lordships permit?
Before, you are really asking something.
Sir, you have defaulted, sir. You have not taken a prompt step.
My lords, I completely
Yes,
agree.
come in the next week.
Very well, my lords. Obliged, my lords.
In Township for the petitioner. Undertakes to serve a copy of the petition of Mr. Misra. Learned in the
Standing down.
Learned standing down, so in course of the day. List on.
Yeah.
List on 9th. Yes.
Obliged, my lords.
Yes.
Okay, item number 2.
Let it come on Monday. But conducting confiscation.
Sir, what type of prayer, sir, you are making? You are making a prayer, inviting them, rule be issued upon them to file a counter. What is this? So we are directing them to file counter and disposing of the writ petition. To file counter.
Should not be resumed.
So we are saying we will give a counter stating why it should not be resumed.
You correct your prayer, sir.
So what kind of a prayer is this, sir? The rule be issued, admit the writ petition, PIN, notice be issued upon the opposite party to file their counter. So we are directing to file their counter. That serves the purpose. No.
You are Mr.
Amend the prayer, sir.
You are Mr. Pikera. Mr. Pikera. You are Mr. Pikera.
P. Bhutia.
What is your name? What is your name?
P. Bhutia.
Mr. P. Bhutial and Council 6 for an amendment of the prayer. List on 15th April.
Item number 3.
Please, your lordship.
Number 3, was listed the Honorable Single Judge. To raise the point about the maintenance, because I'm criminal is the competent court to decide the matter, but my lord cited some decision and my lord has said the type. So let's say we give another 2 weeks time.
Who is for the petitioner?
It's a
Lordship, I am VC.
Somendra Bevre, is in BC.
You'd like to file counter?
Yes, sir. They are
Party,
the cabinet secretary, the
London
party, they don't
DSGI.
need to implement the cabinet secretary.
2 weeks time to file the
Yes.
file the counter. List on
Sorry, my lord, 3 weeks.
3 weeks. List on 6th May.
Obey.
Item number 4.
The matters are there.
Yes.
Next week.
Today is a good day for. Why you are asking for next week?
You are Mr. Mr. P.K. Veral and counsel for the petitioner. Raise for time. List on 22nd April.
Item number 5.
Relating to plant of ordinance, no objection will such a period for construction of a conveyor belt over the municipality road.
That collapsed.
That has been collapsed.
So
There-
it's because of your fault, sir.
No, I am the municipality.
Oh, you're the why
It
you
is
don't have an expert?
I am not expert. That's why so we have made the drawing and designing with the superintendent engineer of the district. He says, I am also not expert. That has been supplied to the chief engineer of the state. He shows the chief engineer of the non-single judge only granted 2 days time to examine the report. With hurried at a short span of time, the chief engineer also opined, I am not expert in the field and relegated to obtain a report from third party. Relying upon that report, the single judge, honorable single judge, allowed to start the construction work with a conditional order. If any report will come, that will guide the continuance of the structure.
Okay.
Yes, what do you say? There must be a competent authority
Yes, yes,
who will
there is.
say how without the competent authority.
No, there is, and he has already certified. I'll just bear with me.
Where he has certified?
Yes.
The third party he says that.
No, my lord.
I am placing my report stating what the report of the chief engineer I am placing.
Oh, sir, let him place. You said that the chief engineer also signifies that I have no expertise in this regard.
Absolutely, your lordship.
So if he says that the chief engineer has said that there is no difficulty, he has an expertise, then where is the difficulty?
My lord, just bear with me for 2 minutes. I'll just give the background. My lord, in 1920, the cement plant was set up. Now, over a period of time, as the cement plant
Expanded.
the township developed. And accordingly, in 1980s, it was declared as an industrial township, as contemplated under Article 243Q of the Constitution. It was, and Section 4(1) of the Municipal Act, it was declared as a municipal township. And the entire roads, civic amenities, everything is maintained by the industry, because it's a civil township. It's industrial township. Now, my lord, for setting up a factory, the competent authority is under the Factories Act. Your lordship may kindly see Section 6 of the Factories Act. May I place section 6?
Please.
Approval, licensing and registration of factories. The state government may make rules, A, requiring for the purpose of this act the submission of plans of any class or description of factories.
Which section? Which section?
Section 6.
6.
Yes. The state government may make rules requiring for the purpose of this act the submission of plans, any class or description of factories to the chief inspector of the state government. AA, requiring the previous permission in writing of the state government of the chief inspector to be obtained for the site on which the factory is to be situated and for the construction or extension of any factory or class or description of factories, etc., etc. It lays down. So for establishing a factory, it is the chief inspector under the Factories Act who is the competent authority. He has to approve the entire design.
No, this conveyor belt is constructed within the factory area or outside the factory area?
In the factory area. Within the factory area. Well, I just explained.
If it is within the factory area, then why?
That is why. That is what I asked.
I'm explaining that. My lord, the two ends of the conveyor belt on which the conveyor belt rests are within the factory premises. There is the belt which runs over the road.
So your factory is divided into two portions.
It's one
is on the left side of the road, municipal road, and on the right side of the municipal road. You wanted overhead conveyor belts to cross.
Yes. And for that,
and what for purposes? For the purpose of the raw material,
my lord, the first belt is for carrying coke. The second belt is for carrying clinkers, and the third belt is for carrying hot air for the captive.
So that must be a chimney or something of the closed.
Absolutely, entire thing is closed. There is no emission of dust or anything. Nothing comes out. The entire thing is enclosed. And this design is to be approved by under the Factories Act. So, under the Factories Act, your lordship may, at this point in time, kindly see the rules framed by under the Odisha Factories rules. The Odisha Factory Rules, 1950.
No, it will not have. It will not. It's only a factory rules to the center.
Sir, your lordship. Rule 3 is relevant, my lord. Your lordship may see. Rule 2 of Rule 3 is relevant. Subroute,
Let me understand,
yes,
because,
yes.
only for the purpose of
No, yeah.
clarity and the more, the understanding of the aspect is.
Yes.
The factory is set up at a site for which the permission or the license is granted to you to undertake up manufacturing activities. For that, there is no difficulty that the license and the permissions, everything is to be granted by the state government. If the factory is situated across the road on both the sides, so far as the roads are concerned, it is within the domain of the municipality.
No, man, it's not under the domain of the municipality.
Because it does not, because I am telling you, if you come to the definitions, section 2, what troubles me, I'm just trying to
Yes, my lord, my
have
endeavor
the
would be
extra
to
copy. Yes,
satisfy your lordship.
Give him. So we have, don't worry. We have the copy. Please come to the definition.
Yes, my lord, I am at the.
Yes, first you come to definition, section 2I.
Yes,
Transmission machinery.
Yes, my lord.
Means any shaft, wheel, drum, pulley, system of pulleys, coupling, clutch, driving belt. You are really concerned with the driving belt.
Right.
Or other appliances or a device by which the motion of a prime mover is transmitted or received by any machinery or appliances. Because you wanted to transmit those from one side to another side for more purposes.
This comes within transmission.
Correct. And then come to K, that's the manufacturing process.
Yes.
It means any process for making, altering, repairing, ornamenting, finishing, packing, oiling, and all, everything is there. Transforming or transmitting parts, transporting or delivery or disposal, everything is included. This is within the manufacturing process. Then comes to the definition of a factory. M.
Yes, sir.
Means any premises including the precedes thereof. This is what is very important. Precedes thereof. We had 10 or more workers. Now it is coming. If there are more than 10 workers, then it will come under the factory.
It comes.
The word precedes have to be understood.
Yes.
What is the precedes?
Yes, ma'am.
The precedes is the site which is allotted to you. Either you owned it or the lease is granted by the government for that manufacturing premises. So within the precedes, if you want to do anything, then it will definitely come within the purview. Now, when you cross the road, municipal road, the aerial obstructions or the aerial, the space you want to utilize over the municipal roads, whether it would come within the purview of a factory, because it does not come within the precincts. It is outside the precincts of the factory. If it is outside the precincts, then section 6 is only for the purpose of factory. So one has to understand.
Firstly,
so it is a municipal authority who is controlling everything.
That is why I began by saying that this has been notified by the government. The entire area, including the road, has been notified as industrial township. That, my lords, I will show to your lordships in a moment. Annexure 8.
Annexure?
Annexure 21.
21.
Flag B. Annexure 21.
21.
Yes, my lord. That is at flag B, that affidavit which was there.
The declaration of industrial township will how help you?
It will, my lord, the entire thing, even the roads, civic amenities, everything comes within the domain of the industry.
No. Where from you are getting?
243Q, your lordship may see article 243Q of the Constitution.
Then Mr. Mukherjee, there will be an interesting thing that would come. Suppose the government decided to set up a satellite township.
Yes, correct.
And the purpose and the object is to accommodate the peoples. That means that would be integrated somewhere, and the roads and the civic amenities, which are the primary responsibility of the municipality or the panchayat or whatever, if it is there, then it will rest upon them. Or then the purpose, the purpose of setting up the township would be totally frustrated.
Township is to be established by the industry, not by the municipality.
No, it's an industrial township. There are two ways of looking at it. If the industry set up and the industry has also provided the civil amenities to its worker within the precincts,
Yes,
within the precincts,
yes, sir.
then it is the duty of the industry
Yes, sir.
to look after the every aspect of it.
Absolutely,
No doubt.
absolutely.
It is not a case of an industrial township which you are saying. When the municipal road crosses,
It is not the municipal road. It is not a municipal road. It's a public road. It's
what
a
do you mean by a
road
public road?
connecting two parts of the municipality. Matlab, Rajgangpur town.
Then suppose if there is any kind of a damage which is done to a road, whose primary responsibility is
It
to
is my responsibility.
maintain the
My
road?
responsibility. My lords, that is the purpose I wanted to invite your lordship's attention to Article 243Q.
Yes,
243Q,
yes.
Constitution of Municipality. Your lordship
Absolutely, I'm
has-
aware. That's why I'm asking you that why you are referring it. Just wanted to decipher why you're referring.
Your lordship sees the first proviso.
Yes,
Provided that a municipality under this clause may not be constituted in such urban area or part thereof, as the governor may, having regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area, and such other factors as he may deem fit, by public notification, specify to be an industrial township.
yes.
Now, my lords, your lordship sees section 4(1) of the Municipal Act.
Lisa Municipality Act 1950.
Yes,
Page,
page 69 of.
no, I think section
Section 4.
4. Yes,
4(1), again the proviso to section 4.
yes.
They shall be constituted by the state government in accordance with it, provided that no such council or corporation shall be constituted in any urban area or part thereof, which the government.
It's a reproduction of the same thing.
Yes, my lord.
So this is really brought by virtue of that.
Yes, my lord.
So now,
At this juncture, your lordship sees section, the annexure 21.
was there any notification, public notification in this regard by the
Yes,
governor?
that is annexure 21 of the writ petition. That I have, your lordship will find at flag B. Flag B of the writ petition.
Where is flag B?
Yes.
Please do that. Flag B.
Physical copy.
Physical copy.
Physical copy is available in the records.
That is a read petition.
May I share my copy, my lord?
Read petition. Double petition.
31160. It is there.
Yes, madam. 311. There's a flag B there, which is additional affidavit filed on 3rd of January 2025.
Flag B is caveat.
Flag B.
Which document you are referring?
The additional affidavit filed by the petitioner on 3/1/25.
3/1/25.
Yes, madam.
Yes.
Your lordship takes page 8 of that affidavit.
You got it.
Oh, that's the 23rd December 1998
Yes,
notification.
madam. Yes, madam.
I'm reading that.
Yes, madam. Whereas OCL Limited, that's me, Manoj, Rajgangpur, is
525 acres of land in Mauja, Rajgangapur.
it covers, Manoj, this road also. It includes this road. So, Manoj, everything.
The bounded description is also given.
Yes, Manoj. Yes, Manoj. Next page. It's good.
Is a north, south, east, west.
Yes.
So it comes within the
Yes, yes.
purview of that.
Yes, it comes within that.
Okay.
So, Manoj, everything.
So amenities should be provided by them, the municipality.
No, by us.
So
By
it
us.
says that whereas the transfer of assets and liabilities of the said municipality to OCL
Yes.
shall be decided by the committee constituted by the state government within 3 months from the date of such consultations.
It has happened and we since 1998,
Then why you need a permission?
we don't need. It is only for the purpose.
If that being the position, then the municipality does not have any role to play in this regard.
If they don't
Then
have any-
why earlier you approached the municipality and why it
Because-
was granted?
We had initially taken the permission in 2006 when everything was at a very inchoate stage. In 2006, when we applied for permission for installing, putting up
The
the,
position that the municipality installed. And then why you approach the municipality?
now, Manoj, they had given us an NOC in 2008. They had given a third NOC in 2015.
Why the municipality? If the municipality has nothing, they
It
can't
has
exercise their
absolutely no role
powers.
to play.
Then in that event, why the municipality should be approached?
They have absolutely, but they cancelled the license, they cancelled the NOC.
And if
they
the
had given-
entire area is now transferred to you
Yes, Manoj.
by virtue of the notification,
Yes, Manoj.
then why the public road? Why it is to be? It must be a road,
It's
a
a road.
private road,
It's
not
a
a
road.
public road.
It connects to part of the municipality.
Whatever, that's up to this. If the township is too large,
Yes.
which expanded over the two municipalities, then road which is within the industrial area, that's your road.
It's my road.
Then why you say the public road?
Public is
That you permitted,
the municipality are
since you are permitting them to use it.
Yes, Manoj, I am permitting them. to use.
So through a township, you can go, but that's not a public road
It's a.
because the maintenance lies with you.
Yes.
Even a civic entities, everything has to be
everything,
borne by
water,
you.
electricity, drainage,
Then
everything.
why you have accepted this? You have accused your right, now you are asserting your right.
I have accused my right and have asserted my right by means of law, Manoj. I will satisfy on that aspect also.
Yes, we want to hear. This is a very interesting point.
Whatever my non-engineer raised at this time in objection to writ appeal, that is itself contrary to the our mention in the writ petition. In the writ petition, my non-engineer raised, this is a municipality road, they have applied road and they have accepted as municipality road.
That is why I said that you have accused to your right, then now you can't take. But it's an interesting point, I tell you. If that being the position, we want to hear out.
Well,
That let us see, because otherwise we have to stay the operation of the order as well. That's a mandatory order which is given upon them. What is the direction? To within 2 days?
No, but that has already worked out. That is the first thing which I wanted to.
What?
The learned single judge directed that the NOC shall be granted by the municipality on compliance of these claims.
no matter.
Those, just one, allow me to complete.
Sir, let us.
Allow me
Don't
to
worry.
complete.
Don't worry.
Question has been posed to me.
Don't worry. The wavelength has already been matched with him.
Well, since my learned friend is disputing, let me read out the directions to your lecture.
Then kindly consider one thing.
Yes,
What you are arguing today is something very interesting and very different. You cannot blow hot and cold at the same time. If you say that municipality has no role to play, then you cannot take advantage of anything to be done by them. Why they are required to issue a no objection certificate if they have nothing to do in this regard?
they have nothing to do in the matter.
Then why they will be compelled to give a no objection certificate. So in that event, we have to just wait for that.
At this juncture, there is only one thing which I would, the two provisions of the.
Absolutely.
To answer your lordship's query, may I just bring to your lordship's notice certain features of the Municipal Act and the rules thereunder. Section 255.
Why? If the municipality is not there, absolutely kept outside the purview thereof by virtue of this 1998 notification, then what is the use of going into the municipal law? It is applicable only where the municipality exercises their powers. Here your argument is absolutely they are non-existent so far as you are concerned. Then why? So that is what I'm saying. If you
my answer to that would be this, my lords, that even besides the people living in this township or the coming directly under the township, there are people who are living within the municipality who are using this road.
The safety and the security, safety and the security lies with you.
Yes, ma'am.
The municipality cannot ensure that what is to be done, nor they can give you a permission to do it.
Yes, ma'am.
It is absolutely your business.
Correct.
So why? It's a easementary right which you have provided to a public of any of the municipality to use your own land. You may discontinue that easementary right. You may continue with the easementary right. It is up to you. And if they acquired a right of easement by virtue of prescription or by virtue of a necessity, it is up to them to do it. But you can't. If you argue this, then it appears apparently that the municipality has no role.
No role.
Then how the single judge can direct the municipality to do a certain thing?
No, kindly see the direction.
Direction is to issue a no objection certificate.
No.
Then what?
Kindly see.
To start the construction work subject to outcome of the technical expert report. Technical report, before submission of technical reports, permission has been granted to construct the conveyor.
Para 10, please.
Kindly, may I read it? Please it.
Of the impugned judgment?
Yes, ma'am.
Yes, sir.
The response and the concern expressed by Mr. Satvati, learned counsel for the opposite parties.
No, it's a copy of the letter. First annexure, I think. Copy of the judgment.
Yes.
Which paragraph you are reading? 10.
Yes.
Yes.
Recording the response and concern expressed by Mr. Satvati, learned counsel for the opposite parties, the court is also of the view that the petitioner should immediately be allowed to commence the construction with regard to the proposed conveyor belt, completion of which would depend on the soil testing report obtained from any reputed organization. If any such modification is found and considered to be necessary and expedient, depending on the soil testing report received as is undertaken and assured by Mr. Parija, learned senior advocate, the same shall be strictly complied with, which shall further be in compliance of the opinion of the Engineer-in-Chief, Directorate of Design, Orissa, Bhubaneswar, which is to the effect that the results of the soil test along with the required engineering properties are to be intimated to the designer and the vetting authority before execution to ensure structural strength and stability. With the above observation and direction, the writ petition stands disposed of. It is further directed that any construction to begin henceforth, the petitioner shall take all necessary measures to ensure safety of the public at large with the assistance of the municipality, complying with all requirements as may be suggested in the report of the Engineer-in-Chief, Director of Design, Odisha, Bhubaneswar. Now, my lords, after this order is passed, your lordship
then the question would be, again, when you selected a site to establish a factory, then the permission has to be granted by the competent authority under the Factories Act.
Yes.
The structures for continuing with the manufacturing activities, design, everything has to be approved under the Factories Act.
Yes, Lord.
The permission to make constructions should also be granted by an authority under the Factories Act.
It is granted.
No difficulty.
Yes.
If it is all under the Factories Act, these authorities are defined there, the state government, then why this engineer, the design, everybody, why should they will come?
Because
under this?
they were insisting. Municipality insisted
The
that
person having no domain, having no
and he himself says so. He
having no
himself says
domain
so.
over the project,
Yes, Father.
having nothing to do with regard to the industrial activities,
And
then in that event, why this engineer-in-chief design, the Department of Design, that would be
my lord,
coming into place?
that officer has twice been approached by municipality, and on both occasions he has said that this is not within my domain. It is within. Please consult the engineers of NIT and IIT, and we have also approached the NIT and IIT, who have also certified that this is
And very interesting, the soil testing report should come before the construction starts or after the construction starts. It is really putting a cart before the horse.
It has come before the construction.
But the direction is otherwise.
But it
The
has
direction is otherwise, that you can continue with the construction. That will depend upon the soil testing report to be obtained subsequently.
User, my lord, the construction means, first of all, I have to put up the pillars, I have to put up the infrastructure.
The soil testing report must come, because whether it can support. If it cannot support, then there must be some activities which has to be undertaken to make it support. When any construction starts, the first and foremost thing is the soil testing report.
Your lordship may see this, and all this has already been submitted. Your lordship sees. These are post the disposal of the writ petition. This is what has happened.
Sir, there is no direction upon you. There is no direction upon you.
The road, municipality road, that has been admitted. Now, new story they have created, this is within the industrial township and within the purview of the Dalmias made.
But this notification you cannot defy. Can you show us that this notification has been diluted subsequently or superseded by any other?
It is not in respect of that municipality road. That is defined and declared as municipality road.
Have you given a name of that? Have you shown it in your
That's right.
the original map?
They have applied in the year.
What are you saying, Mr. Satpathy, that this is municipal area? Can you produce a notification to that effect?
I have to.
Then what?
No,
This is the basic document you require.
Since the.
When if you are claiming that it's a municipality area, then the first document you require is that the notification of the municipality.
Since there is no dispute as on date. On the date of filing application.
Do you take care of the maintenance of the road?
I am taking care of the maintenance of the road.
How do you say?
That is the municipality road. That is not.
Have you spent a single money?
That road, we are not within the boundary area of the.
No, it is your assertion only, or any supporting document you have to show.
That document needs not to be filed because there was no dispute as till date. The oral submission made by.
They are now disputing, sir.
I am fine with the.
He's
act on record.
He is relying on a document which is already there, a part of the record.
But
now there is a governor's notification. The governor's notification says that 500 and something hectares of land or acres of land, I do not know, that has gone to them.
That land.
And with the boundaries, if the road is within the boundaries.
Now, not within boundaries, that has not been specified. The boundaries of the.
He says that it is within that particular boundaries which is given in the notification. We'll take it a statement. If it appears that his statement is absolutely wrong, we will put them to task. How can you make a wrong statement?
Totally beyond record, nowhere in the writ petition, in the counter affidavit.
No, you see, you are the writ petitioner.
No, I am the writ petitioner.
Oh, sorry, he is this.
He admitted this is municipality road. He admitted
petition.
What you have said?
additional affidavit. That is also pertinent to mention that the Housing and Urban Development Department, Government of Orissa, by notification, has declared the petitioner's plant at Rajgangpur as an industrial township.
Correct.
It is submitted that the overhead structures have been constructed within the industrial township.
Within the industrial township and within the road, over the road.
How can it be?
That land.
Sir, probably you have not seen that notification which he had. The governor has issued that notification. I'm saying that this is the area in this particular, I do not know, Mauja or something. What is the word used is?
I have to.
Mauja. Within that Mauja. And then with the clear boundary that on the north, south, east, west. So when this is demarcated.
That I have to examine.
Examine and is an interesting point.
Must have seen.
No. That is not. That is in shape of additional.
You are saying, sir.
No. That is in shape of additional affidavit. It's coming, and this point has been raised first time in before this office.
Correct.
No. He has raised it in the writ petition.
No, Miller.
No.
I have read.
He has read it out in front of you. Then now you are saying.
The additional affidavit.
That is a part of the writ petition, sir.
I am reading
That was accepted. What is the additional affidavit? The affidavit.
Affidavit?
If it is
This
filed
is
before the writ
industrial
court, please, if it is filed before the writ court, the single bench, then you had a notice that they are relying on it. So it becomes a part of the record.
Part of the record.
How can you say this is the first time? This
The road is not within the town.
Yes, here read out paragraph 6.
That road is beyond the industrial plant area.
Sir, did you counter it? The affidavit, additional affidavit, did you file your counter to the additional affidavit?
There is no such record.
Sir, I am asking you, did you file any counter affidavit to their additional affidavit?
I have filed counter affidavit declaring this claim with the government that this is a municipality road and this is undisputed.
How can you assume
that is
under 243Q?
The page number 4.
Mr. Sakpati, you are striking your head against you.
We do not want to interfere with this at this stage. The interesting point of law, we are not going on any interim order to be passed at this time.
Is to operate the bed. There is no safety measures have been taken by
whatever you will take care of that. And we are not powerless that in the event where your contention is accepted, we will direct the demolition thereof.
That operation will be taken by
the word operation.
One paragraph.
The loss which the industry would suffer, who will compensate that?
There are two belts. One belt is already functioning. Only in respect of the collapse belt. That
belt also crosses over the road.
The 3 belts. They have approached 2 times for permission, madam. And they have meant 1 paragraph, madam. I am reading.
You see, the single just direction includes that the petitioner shall take all such measures to ensure safety of the public at large with assistance of municipality.
Granting permission by
then why you need a stay of this order?
Well, I need a stay order. They have not made any. They practice premises granted permission.
No, you come ready, sir. We'll hear a day. We are not granting any interim order.
Unless if the interim order is granted,
no, we are refusing recording your submission. That the point which is raised is we want to. This is a very important factor. If it outside the purview of municipality, you can. Yes.
So
if it is outside,
whether you want the interim petition will lie over, or you want a rejection. Lie over. Mr. Sakpati for the petitioner and Mr. G. Mukherjee and associates and senior advocate. Please turn 23rd April, as prayed by Mr. Sakpati.
Then you come with the point. Admission relating to a law is an admission that would stand against him.
Admission of fact.
I'm again, admission, suppose they say that yes, but you do not have under the law. Can it be an admission?
No.
Come with that line of judgments.
Madam, can it be instead of 23rd, can it be 29th?
29. Mr. Satpathy?
construction hurried
Speak in English.
construction na complete hai nahi construction
Speak in English.
No, I understood. He says that whether the construction has been completed or not, he asked. Don't worry.
Yesterday evening.
21 and 21 25 21
I was praying after 20.
What is the difficulty,
after
Mr.
23rd,
Mr. Counsel, please, if he wants, then come on 21. What is the difficulty? 21, 20.
Well, I will be permitted to place on record by way of an affidavit the documents which have come in post disposal of the writ.
Then we'll have to seek for an additional evidence, then we'll have to take out an application. It can't be done in this way.
As you know.
Then the leave under Order 41 Rule 27 has to be obtained, otherwise we can't.
As you know.
Item number 6.
Every year, the petition was an application for option of the option.
Sir, why you will withhold that money? He was unsuccessful and he was not allotted. Return the money to him. You can't keep the money with you.
For approaching the authorities, yes.
Oh,
I
why?
have already submitted a representation matter.
Allowed by
Page
kindness
20.
The tender process.
Page 20. 2 lakhs, EMD and 3 months, EM.
What is the EMD amount? That
Earnest money deposit was, EMD was 7,98,000 and the application fees of 2 lakhs.
2 lakhs.
So, return.
The option was not conducted.
What approach?
But he has not approved the authority.
No, there is a representation.
Page 20.
Page 20, your lordship may kindly see, there is no acknowledgement, no date. Whether this has been presented before the authorities.
Oh, that is a serious issue, sir. Oh, what is this?
You have approached my lord.
Where is the receipt that you have? There must be a seal or something of that kind.
there is also no date.
No, there. I have
You
to ask
have
my
prepared
client.
and appended it.
No, man. Not that.
So we
Not that.
it's not that. It's a premature, it's not.
That is what. And Mr. Guru and Mr. Das and considering the limited grievance of the petitioner that was which is relating to refund of the EMD and
Application.
EMD and application fees for unsuccessful bidder.
Not unsuccessful. No auction took place because of the interim order passed by this honorable court in another repeat.
For no auction took place, we dispose of the writ petition at this stage without expressing an opinion on the merits of contentions of the petitioner, with the direction to OP number 4 to consider the prayer of the petitioner, which consider the prayer of the petitioner within a period of 3 weeks from the date of receipt of such prayer. Stop. The petitioner undertakes to submit his written prayer by way of representation within a period of
7 days.
7 days from today, along with a copy of this, attached copy of this order. Urgent copy.
Item number 7.
Yes, my lord. And last page number 25, annexure 5, my lord. The order of this honorable court passed in this case, my lord.
That was to make an application before the authority.
Yes, my lord. To allow the
Is there any outer cap which is given? The appellate authority, is there any outer cap? I mean, the maximum period of condonation provided in the statute?
No. That's the reasonable ground for granting the.
That's only on the sufficiency of the cause.
Right.
Irrespective of the period of delay. There's no outer cap
Right.
that beyond 90 days cannot condone or something like that.
Right.
Why you should be so technical? Decide on merit and then throw him up. Impose.
Madam, here the merit is under the petitioner filed with form 10BB instead of 10B.
due to mistake or oversight of the auditor of the petitioner, my lord. So this
So
honorable
your
court,
condonation application has been rejected by the appellate authority.
this is second time, my lord. First time the honorable court allowed, my lord.
Hey, so this is the condonation application.
Already allowed by honorable court, my lord. The order of the honorable court.
Then
my lord.
what is this impugned order? This is the condonation which they have refused.
Second time, my lord. The first time they have refused. Again, I came.
Sir, this order we are concerned
Yes, my lord.
is the rejection of your condonation application.
I could allow my controversial petition, my lord.
What is this order? I am reading at the order at page 12.
No, my lord.
What is this order?
25. My lord, page 25. Kindly have that.
25. Okay.
Yes, annexure 5.
So I'm reading a wrong one. Annexure
5, my lord.
What you are challenging, the order of the Honorable High Court or order of the authority?
Honorable High Court allowed in favor of this is the second time they are.
Sir, which order
Annexure 1
of the
without judice. And annexure
which
1.
order you are assailing in the writ petition?
Annexure 1, my lord. Page.
Annexures. That is what I was reading, page 12.
Yes, my lord.
Come to the last portion. Please. Paragraph 7.
Yes, my lord.
What it says, in view of the above reasons and based on the merits of the case,
Yes, ma'am.
it is concluded that the appellant filed the application filed by the SSC for condonation of delay
Yes, ma'am.
is hereby rejected.
Yes, ma'am.
I asked you
Yes, ma'am.
that this is what the order is there. Your condonation application is rejected.
My lord, my prayer is, my lord. Donation petition initially. I came before.
Sir, understand.
Did you get the point? My prayer is, my lord, have no power to over exceed the order of the honorable court, my lord. And
What?
And
What the honorable now when I am very technical, then I am becoming very technical on this aspect.
Annexure 5 kind.
Tell, yes, annexure 5. What it says?
But annexure 5.
Yes.
Yeah,
What is there?
Mr. Sonara, advocate, which is submit that he submit the income decision, my lord, the previous convention delay, the cancellation of convention delay.
Yes.
Decision 23rd October 23, Commission of State Exemption.
So
Rejecting his client.
I
application.
understand. There it says that the condonation of delay in filing form 10B.
Yes, my lord. Para 4, my lord.
Correct.
Yes, informed decision.
He
is set
says
aside.
that the reason was mistake filing of form 10BB.
Yes, my lord.
Correct.
Instead of B.
The court says that you are given a permission
No, my
that
lord. Para
the
4.
application be accepted for form 10B.
And to stand duly submitted.
What does it mean?
Means some.
That in the state of form 10BB, the authority will accept it as under form 10B,
Yes, exactly.
but the condonation remained.
Exactly.
Then the condonation remained. Then the authority has to decide
Yes, my
the condonation application. He has rightly decided to reject it. That will make you happy.
lord. What allowed my condonation petition, my lord, allowed me the para 4 says the decision.
May I give you an hypothetical example? You filed an appeal before us, captioning as WAD beyond the period of limitation. The court noticed no, WAD is wrong. Treat this appeal as WAC. Does it mean the condonation is done by the court? It is change of nomenclature. So it was only a change of form. Instead of form 10BB, the court directed treat it as form 10B, but the condonation remained. That has to be decided by the authority. So why you are taking advantage of this?
My prayer was before the condonation petition specific that my reason for delay is that by mistake filed the form.
See,
But
when
without considering
I was with you, you insisted to go for this order. So I have gone through this order. Now I am not with you. Will it do?
And let the matter be decided on the merit. The Commissioner of the District.
Sir, we have given you a relief and you are not understanding. If you do not know, then what can I do? We asked him that why don't you decide the appeal on merit? What for? And you are insisting for a High Court order. So we have seen the High Court order as you invited us. Nothing. So we are rejecting. That will serve the purpose. No. Then decide on merit. What is that? This is the second round of litigation before this court at the behest of the appellant. Writ petitioner. The authority rejected the application for condonation of delay, as a consequence whereof the appeal filed before the appellate authority to dismiss, as the appeal was filed in form 10BB.
Which is not appeal, my lord. It's a revision, my lord, before the
Revision 10BB, though it ought to have been filed under form 10 capital B.
No, my lord. It is regarding it is a form to file the statutory audit report in a written form, 10B. This is not appeal form 10B.
So what is form 10B?
10B is the audit report to be submitted before the website of the department along with the return form.
Okay. So what is this rejection comes? This is an application which they
only for condonation.
You just hold off. This is the second round of litigation before this court at the behest of the petitioner, raising a grievance relating to a decision of the authorities in condoning the delay in filing form 10B under section 119 within bracket 2 within bracket small b of the Income Tax Act. The earlier rejection was founded upon the technical issue having raised by the authority that that instead of submission and in Form B 10B, it was filed under Form 10BB. He said order was assayed before this court, and by an order dated, write down the date.
27/8.
The writ petition was disposed of, directing the authorities to treat such application to have been filed under Form 10B and to proceed and proceed to decide the matter. By the impugned order, the authority have refused to condone the delay, taking into account that the explanation offered occasioning the delay is not satisfactory. More particularly, it is obligatory on the part of the SSE to explain the delay on day-to-day basis. Stop. We are not unmindful of the proposition of law that the purpose of incorporating the provision relating to a limitation is to avoid any delayed application and to bring certainty into an adjudicatory process. It is aimed to give quitus to an issue in relation to a dormant and lethargic litigant / SSE who cannot approach the authorities at their sweet will. That too after an inordinate delay having caused. Equally, we cannot overlook the fact that the statute bestowed power upon the authority to condone the delay, provided the person approaching such authority provides a satisfactory explanation resulted into filing of the delayed application, or in this case, Form 10B. It is no doubt that unless there is a satisfactory explanation offered by the SSE, the authority cannot condone the delay simpliciter on the ipsit dixit of the prayer made in the said application. The SSE must give a sufficient explanation which is reasonable, plausible, and constitute a sufficient cause to exercise the powers conferred under the statute. It is not necessary that the day-to-day explanation is required. But there must be a continuity of the events, which on a meaningful reading thereof would complete the chain of the events, provided it comes within the ambit of this within within quote, sufficient cause appearing in the statutory provisions. Neither the court nor the authority should take a pedantic approach in finding out the fault in an application for condonation or delay with an intent to achieve the dismissal thereof, but must adopt a liberal and justice-oriented approach so that the justice may be imparted and the cause raised is decided on merit. It appears to us that the authority have taken a stricter view and without adverting to the explanation offered, have proceeded on the basis of the ratio of law culled out from the various judgment of the apex court. So the law has to be applied not in an adjunct manner, but on in the perspective of the context, that is the facts involved therein, as each fact cannot be equated with the other facts, and therefore a pragmatic approach is required in relation to an application for condonation of delay. Stop. We after looking into the explanations offered and the fact that initially the petitioner approached this court against the decision of the authority taken on the basis of the technicalities and the reasons which occasion the delay, we are satisfied that the petitioner was prevented by a sufficient cause in not filing the said form within the statutory period provided therefore. So, we do not find any fetter on the part of the authority in condoning the delay, as no outer cap is fixed in the statutory provision, and therefore the authority ought to have condoned the delay instead of dismissing the form on the anvil of liberation. The order impugned in this writ petition is hereby set aside, as a consequence whereof the application for condonation of delay filed before the authority stands allowed. The authority is directed to dispose of the matter. What is this?
Material 2, my lord, the OP2 may consider my form 10B.
Is directed to consider the form 10B under section 119 within bracket 2 within bracket B of the Income Tax Act on merit, and it is expected that the said authority would decide the issue after providing the reasons in accordance with law. Should we put a timeline?
2 weeks. 2 weeks.
No. Should we put a timeline because we don't know how much they are pardoned?
No. No, directly.
Yes.
The direction.
2 months, 4 months timeline we want to put a
2 months.
No, we call it within 2 months from the date of the communication of this order. That's all. Now you are happy.
But your face seems unhappy.
It's still in the state of confusion.
No matter in singular matter already, Bombay High Court, exactly identical issue. The court itself allowed for.
Why you are traveling more than 1,000 kilometers? You have a judgment within 0 kilometer. Yes.
Item number 8.
Item number 8 already, the singular order was passed. I will second the case.
What similar order?
Already an other matter already same petition are same, my lord, the assessment is different.
What is the order date?
This is the 10BB and 10B.
No, man.
No.
Then?
Ex parte order original one.
No.
Oh, this is covered by my order. My brother was not there. He has the right to dissent. Convince him. Convince him. Argue.
The ex parte order without opportunity of hearing or without so called notice served on the petition.
My query is that
Item number 9.
this, sir.
My prayer is only calling upon to suppose why the appeal order dated 2024 and it's the one passed by the Petition number 2 and the order dated 3/5/2023 passed by under section 73 of the Act Annexure 4 by the Petition number 3 shall not be quashed being the document submitted by the petition not verified properly. Your Lordship, my humble submission is in indirect tax cannot be levied on the basis of 26 AS. 26 AS is only the reflection of the payment of direct payment. It is the person who deduct the tax. It will be reflecting 26 AS, the person who disbursed the payment. But in indirect tax, there is if a works contractor implement a works and receive the payment of money from the person who paid the money. In that case, the only payment is reflected in 26 AS. But there is various aid. A person who is executing the work, there is administrative expenses, there is other labor expenses. In that expense 26 AS total entire reflect only. But in the GST Act, tax it is an indirect tax, and tax cannot be levied on the basis of the 26 AS. 26 in this case, Your Lordship.
What is this 26 AS?
That is the
Income Tax Act.
The payment which is
I have already clarified the authority, but they have requested my in so-called also I have clarified. You cannot levy the tax on the basis of 26 years.
If it is an income on tax.
item number 8, no? 9. Yes,
Yes, 9 supplementary Gayatri Udyog.
The detailed order has been passed, then not basing on 26 years.
Yes, that you in so-called reply I have given in audit report.
This is the assessment basing on the audit visit, audit report.
Your Lordship.
Audit has been conducted under section 65 and basing on the 65(6) report, 73 has been initiated and there are many other grounds. Your Lordship may kindly turn to page 31. The annexure to the order, there are many issues. Not basing on 26 years, the assessment has been done. The entire books of accounts has been audited. Your Lordship, this audit report is at page 16.
60.
16, Your Lordship, the audit report.
16.
Starting from 1/5.
So the assessment was on the basis of this, the
Yes.
demand was on the basis of this audit.
They have.
What have you explained in your SOCOS notice?
I have explained everything. I have submitted audit report. I have submitted my all the vouchers payment and everything. They have received all the.
No, they have not considered those.
They have not considered.
How
They
do you
have
say?
only considered in 26.
How do you say, sir?
Sir, they have reflected in this audit assessment. Audit.
No, you see Annexure 4, it is the order of assessment, no? 73 order is Annexure 4, no?
Yes. Annexure 4 is order of assessment.
No, I'm just talking about what is this order of 29th of November 2024?
That is first appeal order has been rejected.
So they have a right to challenge that
Before the tribunal.
The tribunal is not there. So that is the order, which they have to deposit and then wait for that.
You're not.
That's the only thing, sir. You can't do it. Where is that order?
You're not.
This is the same order. They have to be challenged in the tribunal. But the tribunal is not here. So we can say. Percent of the remaining. Yes, the same order.
So you know, sir, I have not given SOCOS reply.
What SOCOS reply? You go and challenge it before the tribunal, you deposit it and then do it. Why people dispense it? And more particularly, when the tribunal is there.
Item 10.
10 is the same. 10. 10 is
Same.
same. 10 is the same.
Yes.
Item 11.
Challenging the improvement part of Annexure 10. It's 55.
What is this order? 6/2/2025.
No,
Annexure 10.
10 months.
It is same, Mr. Misra. He has to approach to the tribunal.
No, he has to approach first appellate authority without going in first appellate.
Why don't
He
you
has
go?
filed this.
Why don't you go before the first appellate authority? That provision is there. That why jurisdiction should be exercised.
And also time is there. It is
Within time is there.
within
So
time.
approach.
It's February 2025. This order has been.
Approach the appellate authority. This is under section,
Under section 74.
the appellate authority.
On 107.
107. That is what I want.
Yeah.
The writ petition is taken out by the petitioner, assailing an order dated 20. What is this? 22nd November.
No, Your Lordship, it is 6th February 2025.
Assailing an order dated 6 February 2025.
Yeah.
Passed under section
74.
Section 74 of the OGST,
Your Lordship.
which year?
Your Lordship, GST 2017.
OGST 2017. Petitioner has a remedy by way of an appeal under section 107 of the said act. Stop. We are not unmindful that alternative remedy cannot stand as an absolute bar in entertaining the writ petition. But equally, it is true that the court may refuse to exercise such discretion if the alternative efficacious remedy is provided in the statute. We do not find any justification in exercising the discretion so vested upon us. More particularly, the issues raised in the instant writ petition can be raised before the appellate authority, who is otherwise competent to decide the same. So we thus dismiss the writ petition as not maintainable. The dismissal of the writ petition shall not prevent the writ petitioner to exhaust the remedy provided in the statute.
In the meantime, they have seized my bank account.
They will wash it. Don't worry. Go there.
Item 12.
There's a matter relating to my lord.
Item number 12.
Matter relating to grant of license of new IMFL concept at ward number 19 of Potamunda Municipality. Lordship, kindly come to page 11, Annex 2.
Yes.
Since 2020, my lord, the opposite party number 5 has issued a letter with regard to grant of license to me, which is still pending before the authority, my lord, for consideration. My only prayer, my lord,
What is only remaining period for 2019 and 20?
that is still pending, my lord. Since then,
That period has gone now.
no, my humble submission, my lord, the instruction what I have received, the period is gone. As per the letter, the period is gone. But they have not taken any step, any action on that letter, my lord. But it is still pending. And
But
so far as that
authority,
area is
the
concerned,
inspector has to recommend for the grant of OPSOP.
after making, the inspector has written it to the excise superintendent, my lord.
Why? Under which provision? The inspector has the authority to grant, to recommend for opening up a
Because
OPSOP.
he will make the inquiry, my lord, and he will recommend, my lord.
No, unless he is directed. He cannot.
He has made an inquiry and
I did notice. My brother is absolutely correct in this regard. The inspector has said that since you are already running a restaurant of supplying the food, so you should also be granted an online shop, on-shop license.
My humble submission, my lord, after making an inquiry and after finding that I am fulfilling all the needs which is necessary to be open on-shop, my lord, thereafter he has recommended, my
You
lord.
see, there is a scheme, there is a procedure to get the on-shop, off-shop, everything, and the competent authority is there. But why the inspector of excise is interfering with this?
The inspectors are
under what authority?
The inspectors are making inquiry, my lord, and
And this is
How
for
can it be
the
done? Because there are embargo which is created, there should not be
There is
any
a policy,
school within
excise
the,
policy.
within the particular area, there should not be any temple within the area.
no, that
The objection of the local inhabitants are also required to be taken into consideration. All these parameters are there, and it is really a policy decision to be
With
taken,
regard to
whether
that,
to
my lord,
open or not to open.
with regard to that, the inspector made an inquiry and found it to be correct, my lord.
The inspector has recommended. What authority he has to recommend? What authority he has? Simply because that you are running a restaurant and providing a food, and which is a very good restaurant, so you should be granted an online shop, on-shop license also. You are providing a very, I think, hygiene foods to take care of the health of the customers. Why you wanted to? Now I do not want to say.
So now the new excise policy has come, I think 24, Mr. Patra, 24 policy has come now.
24, 25 has been continued because new policy has not come.
New 24
Yes,
policy.
they have existing last year policy they have continued until further orders.
No case, we are rejecting. Mr. Tripathi for the petitioner and Ms. A. Das Lenin Daisy. Stop. The limited grievance of the petitioner is for a direction to the superintendent of excise to act upon the recommendation of the inspector of excise dated 11/3/2020. Next, having had and going through the recommendation of the inspector under Annex 2, we do not see any merit in the contentions of the petitioner or any liability on the superintendent of excise to act upon such recommendation dated 11/3/2020 to permit the petitioner for opening the on-shop. Accordingly, stop. Moreover, now we are in the year 2025 and the excise policy 2024 has come into force. Accordingly, we do not see any merit in the contention of the petitioner and the writ petition is dismissed.
Item number 13.
Why you are not considering the shifting of the shop? You wanted a shifting
No, my
of
lord.
shop.
No, my lord. I am for the villagers of Narayanpur, my lord.
So who is for the petitioner?
I am for the petitioner, my lord. We are objecting the shifting of the shop, my lord.
Oh, you wanted everything to be there.
No, my lord.
They must be in the new area
The new.
where this shifting is being.
My lord, initially what happened, my lord?
So it is better that it is kept at the distant place from your
My lord,
village.
my lord,
It is better for the villagers.
my lord.
Why you are objecting?
But it is in the village at present, my
No,
lord.
no, it is shifted. You want a shifting that it should be shifted.
My lord, it was shifted from Karapalli to Narayanpur, my lord.
Correct.
I am for
You
the
are from
villagers of Narayanpur, my lord.
Okay. Consider the grievance.
Who will consider the commissioner or the collector?
Commissioner.
Why? The collector, I think the appropriate.
I think the shop owner. is that.
My lord.
Then take notice.
Have you served?
No, my lord.
That is why without him. He's a person who has a right to be heard before any order is passed. Give him a notice.
Issue notice. You are Mr.
PN Panda, my lord.
N. Panda. So Ms. Das AC accepts notice for OP 124, notice to OP 5 by registered post / speed post, blah, blah. Office to collect postal tracking report. List on 30th April.
Item number 14.
The excess recovery of commutation pension from the pension of the petition. What? The commutation, excess recovery of commutation pension.
Excess recovery from a community.
Value is the 9,56,000.
According to you, that has already been done. So they are still continuing to
Yes, yes.
withdraw.
Is it a division based matter?
Yes, challenge the virus of the statute.
Virus of the statute.
Yes, yes.
So then, who, the Advocate General, the learned Advocate General has to be.
The affidavit is also there.
You are challenging of Rule 1 of sections of Rule 7.
Yes, yes.
I think it was all right. Take notice.
My lord. In the similar case, my lord.
Under both five.
Yes. In the similar case already.
You are Mr.
I am Tarni Prasad Tripathi.
P.K. Tripathi and Mr. S. Das Lanage accepts notice for opposite parties. How many copies? 3 copies. 3 extra copies. Blah, blah. List on 12th May. In the list on 12th May. In the meantime, counter shall be filed on behalf of the opposite parties.
Recovery may be still. Further recovery till the already recovery level.
How much of worry? Don't worry, it is being recovered for such a long time. If ultimately you win, then they have to return. Don't worry, you will get back.
Till February 2025, my committed value is 9 lakhs.
I understand, sir. You have challenged the virus, and according to them, it is a recurring process. So we can't stay now. If ultimately it is found that they have deducted wrongly, or the law is declared ultra virus, then they will refund you. Don't worry, you get back the money. It's a secured creditor, most secured creditor. Don't worry. Yes.
They refund you with interest.
Item number 15.
I may be permitted to withdraw because relief shortfall has been allowed.
Mr. Patrul and counsel.
Allowed.
Oh,
Mr. Patrul and counsel for the
I'm planning my
petitioner 6 permission for withdrawal of the writ petition. Submission that the reliefs prayed for has already been granted in his favor. Yes. He files a memo to that effect. The writ petition is dismissed as not as withdrawn.
As infructuous. It has become infructuous. Actually, it has become infructuous because the relief that already.
Just it will be permitted to withdraw.
Dismissed as withdrawn.
Item number 16.
May I please be- Service tax matter, my lord. The finance, yesterday, my lord, so your lordship have dealt with this matter relating to violation of 73(4)(b), which mandates of the Finance Act 2014, which mandates that it has to be, the orders have to be passed within 1 year from the date of show cause notice. Similar orders have been passed and matters have been pending. Already given a copy.
And when we can fix a matter and decide, because I do not really want that all these matters should accumulate. So tell us, both of us, one lead matter where you exchange your affidavits and then we can decide and fix a date.
Another point should be finding a counter to that effect, if at all it is necessary.
Shows one lead matter.
I'll verify and give the list.
No, one lead matter, then you, so we can direct in that matter
No,
to
yesterday-
exchange the affidavits.
Yesterday, we have fixed similar matters too.
5th May, if I remember
5th
correctly,
May.
5th May. I've made the necessary correction, of course, without your lordship's
Fifth
permission.
May. Make it on 5th May.
But can we treat this as a lead matter?
As your lordship sees. Adi Lakshmi, Lord, is a matter, I'll give the number to your lordship's.
You are there in that matter as well.
Ma'am.
And
That matter has been.
you are
referred-
also there. You are not, Mr. Tushar Satapathy is there.
Yes, Mr. Satpathy is there.
That can be reduced.
18713, their lordships have also referred to that order, the second page.
Yes.
WPC 18713 of 2020.
18398.
18713.
But it is mentioned.
18398.
Konok Automobiles.
No, that is the Patna High Court decision, which decided in our favor. The lordships have extracted paragraph 10. And this particular order, your lordship may permit me to lord.
No, which.
The lead matter would be, if your lordship show the desires, it would be 18713 of 2020.
Yes, yes. No, it is here. Don't worry. Adi Lakshmi Engineering versus. So, Mr. Counsel, because you are not representing in that matter. So any direction for counter?
No, he's.
Can you communicate to your counterpart?
He's the junior standing counsel for the department. The
So senior standing counsel appeared
in the other case.
without the junior standing counsel.
Say similar order. In the last portion, you write on list on 5th May. And tag this matter to WPC number 18713 of 2024. So, impugned order dated such and such will remain stayed till next day.
Which of them?
Item 17.
The petitioner, the challenge, demand notice under annexure 7.
The counter is required.
Here, the ratio has been decided.
Transportation fees.
Yes.
You are
The ratio-
assuming that
The ratio has been decided by this on court. And this on court held that the demand notice is without authority of law. If it is transport within the limits of prescribed limit.
Madam, you
as
are being-
provided under rule 4.
So what, if the point has already been decided, then what?
Lordship, I have to seek instruction.
I've given
Because this
copy.
was in
I've given copy.
2014, your lordship, what has happened after that, I have to seek instruction. It was decided in 2014, your lordship.
Therefore, the imposition was done when.
Not in 10th March.
It's a matter of
Transportation
2004.
fees.
Yes, no,
This was levied from when?
23, 24, 24, 25, 2 years they have demand. And 23, 24, they have issued no due certificate, that you have no dues. Now they are coming with this demand, Lord.
No, you are challenging their authority.
Yes,
to,
Lord.
to demand the transportation fees.
Yes.
And you have said that this judgment has already.
Yes, Lord.
Decided the same point.
Lordship, kind of
that
that's
it is
base
beyond
6.
their competence.
Base 6, that is there.
So you take care.
I'll take instruction.
That's a fine. The point.
3 weeks, Your Lordship.
What in the instant petition relates to the competence of the authority to impose transportation fees for movement, transportation fees per quintal for movement of the goods.
Mahua flour. From my premises because here all are manufacturing units.
From
go down to Malad distillation.
From the store to a distillation plant. According to the learned advocate for the petitioner, this hit point was also a subject matter of dispute in WP within bracket C number 14493 of 2004. And the division bench of this court has already decided the same, upholding the contention of the petitioner therein. Full stop. The counsel for the state submits that they need strong instruction from the competent authority as to the development having taken place after the said judgment is delivered. She thus prays for an admonition. When, madam? Next
3
week
weeks.
or when?
3 weeks, Your Lordship.
What 3 weeks?
3 weeks.
2 weeks. Do it. Yes. 2 weeks.
But I have paid for stay of demand.
Yes, madam.
Because they will not again extend the license to lot for current year. Because
the
of this
date will
demand
be fixed.
under rule 35.
When interim is passed, then a date may be fixed.
Yes, date is fixed.
We thus find a prima facie case having made out. There shall be an of the demand.
Annexure 7.
Being annexure 7 till 21st, till the next date of hearing. Matters will be listed on 21st.
All the matters.
All the matters same. All the matters. Item 17, all matters same.
Item number 18.
In annexure 7 also in all cases, Lord.
This PI
Who is appearing for the other side? Very good cause, noble cause. They wanted a ladder to be set up everywhere.
Yes.
Is it a digital library or it is a physical library?
Physical library, my lord.
In a digital world.
Because there is state library. And the act and
take an instruction, madam, because this is a very noble cause. It will educate the persons, it will enhance the knowledge. The library.
I will seek instructions, Your Lordship. But 3 weeks, Your Lordship.
The petitioner appears in person. And Ms. Patnaik and AGS 6 time to date instructions. List on 7th May.
Item 19.
And here the petitioner is a licensee of an officer from 2020-21. But he is continuing for last 4 years. Now the Superintendent Excise has issued an annexure 2 directing the SIP the south on the basis of allegation of somebody. But I have not been provided with any copy of the objection and here, Lord, this Superintendent Excise has no authority. If objection is filed, then with regard to shifting, under Rule 53, the Commission is the authority. Lordship just one before case, Lordship is saying that the Commission is the authority. The Commission is the authority. So it is without jurisdiction. Superintendent Excise has issued this.
Seek instruction, Your Lordship.
This has also been held by this own court.
Mr. Patra and Ms. Patnaik, issue notice. Ms. Patnaik issue accept notice for 1 to 4, 3 extra copies, 4 extra copies will be served on her by tomorrow, by Monday. List on 7th May. In the meantime, then write in the IA. In the meantime, write in the IA, Mr. Patra submits that the direction for shifting of this officer by the superintendent of excise has been made without any authority and without granting any opportunity of hearing to the petitioner. Next one.
Item
In
20.
the next one. In the interim, it is directed that there shall be stay of operation of the impugned order under Annex 2 till next date.
7th May.
Urgent copy.
7th May.
7th. Same, all 3 are same.
No. The second item is transport fee matter. Earlier, item 17.
8769.
8769
is same to item 17.
Transport fee more
Transport. The same order.
The next third item, Lord, is different, Lord. Here, Lord.
Item number?
Same item, third sub-item. Lord, 8812. 2025.
What is this?
Lord, here, Lord, my shop was ransacked by the public. Lord, I was directed to shift the shop. I was shifted, applied for shifting of the shop. But what they have done, they have closed the shop under Rule 20, Section 26. In exercising power, there is a law problem. Now their superintendent has recommended that for the closure period, the petitioner is not liable to pay with regard to MGQ duty. And it has been recommended under Annex 7 by the superintendent to the commissioner. But he is not, they have not taken any decision.
What is this? If you have closed it, how you will meet? If he cannot sell, then
entire shop was ransacked. I have lost the affair and everything has been done. The report has been given.
Take next week, madam. We can't grant you a much larger time.
Ms. Patnaik and Council reaches 6 time to get instruction list on 8th.
Lordship 10th.
10th will not.
I have 2 prayers.
9th.
But shifting has been allowed. Shifting has been allowed.
You do
but
it.
they are not allowed to run the shop in the new site.
Therefore, we are fixing it to 9th next week. List on 9th.
Item number 20.
Let them allow the shop at the new site. Old site, I am not there now. Because once new site has been approved by the commissioner, I'll have to run there. But they're not allowed.
Let them get the instruction on 9th. We'll pass it necessary.
Obliged. Not obliged. Obliged.
What is the difficulty? So it's the same matter.
Same matter. Similar to item 14.
So we have already fixed when.
Similar matters have been, I have unmade a copy of the order in similar cases, you also issued notice and also granted. At page
I think let them deduct for the time being. Let them deduct, we will consider it, we will return it back.
As per the rule, I have to pay for 12 years.
I understand. I understand. But now you are really assuming this.
In similar cases, you also have already issued in the order that I have added page 36.
What?
In similar cases.
But your other friend in that item 14, he was unable to.
Yes, ma'am.
Anyhow, let him come. Let him come. The same order when we have fixed the
12th May.
12th May.
About
12th May. On that day. On that day, we will definitely consider. Don't look. And we'll decide the matter. How long they will continue deducting.
More than 12
By
years.
virtue of amendment rule, it is for 15 years.
Yes.
Earlier, it was 12 years. By virtue of amendment rule, it is.
Now, whether the amendment can be given a retrospective
Yes,
effect or from a.
That is the only thing.
Come on, 12, we'll hear out the matter. Come. Yeah.
Item number 22.
One of the matters similar order has been passed lodged by your matters regarding architecture. Who made the necessary?
Yes.
It's a RC rate.
Yes. So they will pay. You'll be a read them all, everything, and this is application. That's all.
Item 23.
The action of the opposite party violating the statutory direction of the 39 of the Prevention of Control, Infectious and Contagious Disease Annual Act, along with the order.
There is already an act here.
Let's see.
There is an act regarding this control of the cattle and all.
And so-
specified animals are also there, scheduled animals.
Yes, sir. And also the annexure 1, the order of the Department of Animal Husbandry.
Yes.
And therefore not taking step regarding the cattle registration, that also the NDLM, National Digital Livestock Mission. And
Yes,
the-
there should be, madam, this is a need of an hour. If there is already an act, we do not follow and implement the act.
The instructions to what the government has done, your lordship, on annexure 1, your lordship. This is from the government of India.
Concerned about the stray cattle, the stray animals. This is what your grievance is, so.
3 weeks time may be given. I'll file a reply to that.
Give a counter, they have to give a counter.
Ms. Patnaik, London does you 6 time to file the reply on behalf of the opposite parties. 3 extra copies may be served on her list on 13th May.
Item 24.
Covered order. Yes, have you seen?
Yes.
What is your name? What is your name?
Yes, yes.
Junior Standing.
Additional handing.
Same.
Item 25.
Item 25 also covered matter, my lord, challenging first appellate.
Yes, you seen that. Yes.
Item 26.
My lord, this is regarding the cancellation of the residence certificate.
Same order.
Sir, same order, sir.
Earlier to earlier.
26 and 27.
26 and 27. Item now 28.
My lord, I am appearing for the petitioner, my lord.
28. Sir.
Where is the petitioner?
I am appearing for the petitioner, my lord. Virtually, your lordship. My lord, is able to hear me?
Earlier order.
My lord?
Tribunal, to go to tribunal depot.
It is also because there is a tribunal, there is a provision for a tribunal and there is
No, I'm coming to that, my lord. I'm coming to that. My lord, I am challenging the impugned orders on grounds of jurisdiction.
Now it is that remedy is provided, you will have to deposit 10% or a 20%.
My lord, allow me to submit 2 minutes, my lord. Kindly bear, my lord.
What?
My lord, the thing is that, my lord, allow me to submit 2 minutes, your lord.
Yes.
My lord, I am challenging the jurisdiction. I am challenging the inherent lack of jurisdiction on the ground that there was a shortage of some goods found in my factory. Now that short found goods is confiscated. And
it has been confiscated.
Yes, my lord. Short found goods has been confiscated, and in lieu thereof, redemption fine is imposed on me.
Yes.
Under section 130.
Correct.
My only submission is that whether a goods which is not available can be confiscated under section 130. For the confiscation of goods,
Then they are required. Then they are required to disclose their stand.
Yes, my lord.
So let them. Then when can you? Because he is raising a plea of law.
Your lordship, only one document let me to school. Your lordship, I admit I
Yes.
Page 65.
What is this?
This is the reply to his, to reply our so-called.
Annexure?
Annexure 4,
Yes.
page 65. This is the reply.
Yes.
This is the consent they have given.
Consent
And
given.
basing on the consent, the order has been-
Agree to pay the due amount penalty and fine in lieu of the confiscation.
And
Can they issue the demand order so as to enable?
the authorized person, after consulting the management of the company, only submits that our company has admitted the stock discrepancy and is agreed to pay the calculated amount of penalty and fine of rupees 100 in lieu of confiscation of under section 130. It was section 120 to settle the stock of goods found to our business premises. Now you let's me kindly turn to.
Now you make out your case.
Sir, he was kind enough to give you some kind of a relief, but since you raised a issue, now he's arguing. If you have acquiesced your right, if you give a consent, and if the order is passed by the authority based upon the consent, can you retract and recite from there?
My lord,
Tell us.
my lord, let me submit. Under Article 265, there is a negative mandate that the authority shall not levy or collect tax save by authority of law. No tax can be collected by my consent. Now, for that shortage, they have already issued another
Show us the provision of law.
130 by
Show
law.
us the provision of law.
Section 130, kindly see, my lord.
Yes, 130. Let us see GST.
Section 111 of Custom Act, liable to be confiscated.
Yes.
And multiple judgments are there.
Judgments are there, my lord, in my
Oh,
favor.
yes, 130.
130, my lord, kindly see. My lord, if you state lords, you can come to the last
Yes, sir.
lines. Then
Please.
all such goods. I am reading from the middle, my lord. Then
No.
all such goods or conveyances shall be liable to confiscation, and the person shall be liable to penalty under section 122. Kindly turn to
Right.
next page, my lord.
Yes.
Kindly turn to next page. Subsection 5. Subsection 5 and 6 are relevant. Where any goods or conveyance are confiscated under this act, the title of such goods or conveyance shall thereupon vest in the government.
Yes.
When the goods are not available, what title can be vested?
Sir, then you'll have to, sir, don't jump. I think you should move in a very serial manner. Please come to subsection 1 of section 130, sir.
Yes,
it
my
says where any person, then first contingencies, supplies or receives any goods in contravention of any of the provision of the act or the rules made thereunder with an intent to evade payment of tax. Then it comes. 2, that is the case which they have made out, does not account for any goods on which he is liable to pay tax under this, because the shortfall means does not account for any goods which was there liable to pay tax. Then it says, then means under these circumstances, all such goods or conveyance shall be liable to confiscation. What is the meaning of the word confiscation? If the goods which are liable to be taxed, if they are not accounted for,
but available.
Available means the physical presence. You are trying to make out a case like
That's
that.
right, my lord.
There should be a physical presence of this.
That's right, my lord.
Yes.
Unless it is physically present,
Then he is liable, and then says any goods or confiscation is made, the title would pass to the government. This is a vesting.
that's right.
Yes. And also, if Roman 4 of subrule 1, if you contravene in any of the provisions of the act or the rules with an intent to evade tax, this is what they also wanted to invoke.
My lord, what I'm trying to
So
make
in
out,
that event, confiscation is defined.
my lord, I am trying to make out, I have contravened the provisions of 131. But what is the consequence? The consequence is that the goods shall be liable to confiscation, shall be confiscated and vested in the government. So what can be vested in the government must be available. If the goods are not available, it cannot be vested in the government. And then it talks about redemption fine, that if I pay the redemption fine, the goods will be returned back to me. Now, when the goods are not available, what can be returned back to me? Kindly see the next one, my lord.
And very interestingly, after 2 years, he has filed the appeal with the plea that the order has not been supplied to him, your lordship. Once it has been uploaded in the portal, 582 days, after 582 days, the appeal has been filed, 559 days. Annexure 3 is the appeal rejection order.
Yes.
My lord, I am challenging the appeal rejection order also on the ground that the lack of jurisdiction goes to the root of the matter and invalidates the all entire proceedings. I am on that, my lord.
Yes.
When the foundation.
No, that's right. If the edifice goes, then the structure cannot stand.
That's right, my lord. I am challenging show cause notice also.
And show cause notice on what ground? There's not competent?
Yes, it is there, my
because
lord.
The scope of writ is very limited in the show cause.
No, I am not against show cause. I came before your lordship after passing of the order.
So after giving a reply to a show cause.
That's right, my lord.
Now we have to see that the order is beyond the competence of the authority.
That's right.
Beyond the periphery of the law, or it is in conformance.
That's what I'm trying to make out, my lord.
And the conduct of the party is also one of the relevant factors.
My lord, when it comes to jurisdiction, which goes to the root of the matter, when the authority is not vested with the jurisdiction.
No, I understand. This is what. That's why I'm saying that there are many things. One which strikes at the root of the competence of the authority. Definitely, the authority cannot. According to you, the consent cannot confer a power upon them.
True, my lord.
They are conscious. And this is started from a very common principles in the England. Legat versus Bull. It is started with that.
Yes,
and is being embraced now.
Yes, my lord.
They are conscious. Let us see that how far this can go. Yes. That's your argument?
My argument is that, your lordship.
Yes. Now, what do you say?
I have already shown the reply submitted by the appellant.
Yes, that is what you say.
Your lordship, may kindly turn to the impugned order, page 47. Annexure 1, page 47, your lordship. Your lordship, the details of the order, so far as the factual findings are concerned, your lordship, this order that has been started from page
42.
42, your lordship. The observation is at page 43.
Yes.
Your lordship, there was a short and season operation and entire accounts have been verified, and the dispatch of quantum is shortage of the stock, your lordship. So this has been supplied. Now, your lordship, accordingly, show cause notice has been issued, and pursuant to show cause notice 47, at page 47, the reply has been considered, and based on the reply, the order has been passed. Now, your lordship, so far as the section 130 is concerned, subsection 1 Roman I itself says that supplies.
Where?
Your lordship, section page 47, your lordship, from the brief.
47?
Your lordship.
Yes.
In response to the show cause notice,
Yes. Yes.
In DRC manually authorized person and CFA, the taxpayer company filed the submission on the very same day on 27th that their company has admitted the stock discrepancy and has agreed to pay the calculated amount of penalty in lieu of confiscation to ensure on the shortage of stock of goods found from their business premises after consultation with the management of the company. That company has also agreed to pay the due amount of penalty and fine in lieu of requested to issue the demand order. And as the taxpayer company is agreed to pay the penalty and fine amounting to so, as per the issued show cause notice, it clearly established that taxpayer company has been supplying goods of so without issue of invoice, which corroborate the fact that physical stock found from the place of business of the company with the equal intention to evade payment of tax and thereby contravene the provision of section 122 and 130 of the rules made thereunder. The contravention of the provision by the taxpayer is the institutional, willful, and deliberate act. Now, my respective submission before your lordship is that section 130 and section 122.
Yes.
Section 130 says that when supplies the goods, your lordship in contravention of any of the provision, your lordship. And more so, your lordship, for the so far as the allegation is that the goods are not available. Your lordship, here the language is that the goods liable for confiscation, which is similar, Your Lordship, to the Custom Act, Section 111. There are many judgments of Honorable Supreme Court, and more categorically, Your Lordship, only one judgment, Your Lordship, I may be permitted to submit, if Your Lordship will permit, Honorable Gujarat High Court has categorically gone through two of the provisions, Your Lordship, Section 129 and Section 130. Your Lordship, both the provisions has categorically dealt with. Your Lordship, I may not require to go all the details, Your Lordship, only that provision. Your Lordship, turn to page 102, the last finding, Your Lordship. Page 102. Only to that respect, Your Lordship. Look at ability. Roman XB. Roman 15, Your Lordship, Roman 15. Even in the absence of physical availability of the goods at the conveyor, the authority can proceed to pass an order of confiscation and also pass an order of redemption of fine in lieu of confiscation. In other words, even if the goods at conveyance have been released under Section 129, so 129 and 130 have been in detail has gone through, Your Lordship, that because the language itself says liable for confiscation, not only the goods, when the goods are available, that confiscation can be done. So, Lordship, that is the law. And if Your Lordship, and the first appeal has been filed after 2 years, Your Lordship, and the first appeal has been rejected on the ground of delay. If Your Lordship is passing the...
No, we are deciding on that issue. No difficulty. When he is raising that point, we are deciding it on a proposition of law. No difficulty.
My Lord, then I may be allowed to make some submissions on judgments, Your Lordship, my friend is given now.
Yes.
It was not liability to confiscation.
Yes.
I have got two submissions, my Lord. One, 131, assuming that the offences have been committed, the moment the offences are committed, goods become liable to confiscation. So far, so good. I agree with him.
Correct.
Now, the consequence of the liability to confiscation, what happens next? If these contraventions are there, goods are liable to confiscation. Now, the next, what would be the outcome of such an offense? That I am on that. Whether the goods which are not available can be vested in the government and redemption fight.
Yeah, we are saying so. We are deciding because it has to be decided on a parameter of I would say the interpretative tools. Let us see that what is meant by the confiscation and how loosely that word is used in the statute.
My Lord, if I am given opportunity for tomorrow, I will assist you, Lord.
Sir, you have raised a very interesting point.
My Lord, that's why I am saying.
We have to decide this point, sir. Very interesting.
Tomorrow, my Lord, I will assist my Lord in a better way. There are a lot of judgments.
Then we'll have to appear virtually, sir, tomorrow.
Tomorrow, my Lord.
Yes, virtually.
Tomorrow.
Virtual court.
Virtual court, my Lord. Kindly allow, my Lord.
Tomorrow we are not holding court, sir. Tomorrow
I am sitting in Rourkela now. It is 9 hours from here.
No, tomorrow we will not be available.
I am sorry. I could not hear that, my Lord. Any day, my Lord, that suits your Lordship.
Tomorrow is what day?
I am sorry. Extremely sorry, my Lord. Extremely sorry. Extremely sorry. Extremely sorry. I am extremely sorry, my Lord. Extremely sorry.
Interesting. Monday, first matter will decide it.
My Lord, I will be ready.
Continue. First matter will decide it.
I will be ready, my Lord.
We will have Mr. Gurmi and Mr. Misra, London Senior Standing Counsel, list on Monday for further hearing to decide the matter finally, as agreed by the parties.
And consider this judgment as a judgment of a Supreme Court as well.
You have seen this judgment.
My Lord, I am on that. I am very clear. I will satisfy my Lord.
That has taken
I will
care.
satisfy my Lord.
Who has authored the judgment? Consider that.
My Lord, judgment. This line is very clear.
My Lord, Jaswant Singh also said the same thing, that it is the only Supreme Court judgment. It is deemed with the Supreme Court judgment.
My friend can give
That's fully right.
Call the next.
Deeply obliged, my Lord. Deeply obliged.
First matter.
Item 29.
Sir, affected by the opening of the liquor shop in the objectionable area, violating the government by the 2024 policy that now presently. The Gram Sabha and the Gram Sasana are not consulted probably.
Yes, what do you say? What is your reaction to it?
So if I may refer to page number 12, point number 1 in that manner, this The above shop may be shifted to the proposed new site after observing all formalities and procedures as prescribed under law. The site is considered and thereafter final order.
No, my lord. This observation part was one. This may not in accordance with the present excise policy 2024. I am placing with your lordship. This does.
No, the shifting is subject to the following compliances. It says that the above shop may be shifted to a proposed new site after observing all the formalities and procedure as prescribed under the law. So that there is no, so how can you say is contrary to the provisions? The second one is should not be on a government land and must be 500 meter away from the national highway and the state highway.
Yes, my lord.
No difficulty.
Yes, no, my lord.
So, three is the location of the shop should be in consonance with the requirement of law. So that is what is there.
No, my lord. The location.
Fourth one is that the ensured that the proposed land to be used is converted for non-agriculture. Suppose if it is for on an agricultural land, they have to get it converted.
No, my lord.
So where is the grievance?
The conditions imposed in the improved letter, the present policy, the objects, the selection of the site is within the, my lord, the prohibited area.
Sir, that is why I say that shifted to a proposed new site after observing all the formalities and procedure.
Formalities are not observed.
No, they have. They have not taken anything. Have they taken any decision? They have not taken decision to shift.
So only they have taken decision and it is
Where is
installed.
that? You have not.
Installed.
No, you have not shown it. You have not challenged it.
No, my lord, it is installed.
Sir, it is not. You have not said anything in your petition. You have not said anything.
My lord, 18/3/2024. So it is.
So are you getting the point, Mr. Manti?
My lord.
So where is the new place of shifting? What is that place?
Place nearby Balikuda.
Where is that place? Have you stated in your representation? You have also not said so.
Yes, my lord.
Yes.
So, Annexure
3,
Annexure 4, my lord. Annexure 4.
What is the place you are mentioned there?
My lord, आम्भेମାନେ ବାଲିସାହି ଅଞ୍ଜିରା କଂସାରୀ ବନ୍ଧ ଗ୍ରାମର ଅଧିବାସୀ ଅଟେ ଗୋଡା ମଦ ଦୋକାନ ସ୍ଥାନାନ୍ତର ପାଇଁ ପ୍ରସ୍ତାବ ସ୍ଥାନଟି ସାଧାରଣ ଲୋକମାନଙ୍କ
ପ୍ରସ୍ତାବିତ ସ୍ଥାନଟି, the proposed place. You have not mentioned the name of the place.
The hospital, school.
Where is the place?
There is a proposed site. That's the real issue. They have said that they will definitely take care of all the norms and the procedures. If they find that the proposed site is near to the hospital, they will not accept that proposed site. May not. So you are simply apprehending.
No, my
No. You have not said that what is the proposed site and then what is the distance of between the proposed site and the hospital, between the proposed site and the school, between the proposed site and the temple. Nothing you have said.
My lord, I will bring these facts into record.
No, nothing. On mere assumption and presumption, you cannot maintain it.
My lord, pray because due to installation of the objectionable area. So,
sir, there is nothing which has come out. Which
every area is objectionable, and every area is also not objectionable. You have not specified the area. Add Mr. Manti and Ms. Das for
we approach the
land and AC for the state. The limited grievance of the petitioner is against shifting of the off-shop to a new place. Stopped. Though the petitioner has stated that petitioners have stated that they have made their representation to the collector Jagatsinghpur, but nowhere either in the petition or in the representation they have said about the proposed site for shifting. Stopped. According as for letter under Annexure 1, the authority have taken a decision for shifting of the offshore to such a place after observing all formalities and procedures as prescribed under the law so that there would be no loss of government revenue and the location of the shop should be in consonance with the requirements of law and the society as whole. So, therefore, the grievance of the petitioners and their objection appears to be mere apprehension on their part without specification relating to new site of shifting. So we are not inclined to.
The new proposed site is mentioned in the order. But
Which order?
this include order of this order. It proposed new site, the name of the place is mentioned, but the shifting is subject to all fulfilling all the formalities.
Site is not mentioned.
It's
Which
like-
plot?
Right.
So that is what we say. Proposed site. The word is used, proposed site. It may be a proposed area.
Plot is also mentioned.
Okay.
This is the office could be mentioned. This is not the website. The main one mentioned.
But that is also, if they say that they will definitely take care of the.
Yes, that's what it is.
They'll have to
That is
take care.
subject to fulfilling all the terms.
Yes.
It is condition, but it is a condition. So
Including an objection from the local inhabitants
Yes,
will also
madam.
be taken into consideration by them. That is one of the conditions of prescribed in the statute. So they will take care of that.
Mr. Manti, you have submitted your objection to the collector.
To the collector.
When?
Annexure 4, in vernacular, page 70.
When I asked you, when?
23, 25.
Where is the date mentioned?
Last 23, 25.
Where is the date mentioned in Annexure 4?
Annexure 4, page 17. Here, my lord, the left side, Tarikh, 23-25.
Yes.
Vernacular, my lord.
23, 2025. Where is the receipt? Who has received it?
My lord, yes, my lord. Above the representation, letter number 419803. It is marked to excise section. Collectors marks in the red. It is marked to excise section. By letter number 419803 by the collector. Office of the collector.
What is it?
Number is given and just Annexure 4.
Annexure 4, page
The top of it, page 17. This number is
419803. Excise.
Excise. Marked to excise section.
Down everything. Add Mr. Such and such. Considering the limited grievance of the petitioners regarding shifting of the offshore to the new site over plot number 3030/3676 of Mauja, Bali Sahi. Bali Sahi and their representation submitted to the collector dated 20 March 2025. We dispose of the writ petition at this stage without expressing any opinion on the merits of contentions of the petitioner, with a direction to the collector Jagatsinghpur, OP number 3, to consider the objections of the petitioners as per their representation dated 20 March 2025 under Annex 4, comma, in accordance with law. And in terms of the conditions of shifting as per letter dated 18/3/2025 under Annex 1, comma, within a period of 4 weeks from the date of receipt of certified copy of this order.
Item number 30.
Like they giving opportunity of hearing to the. Because
if necessary, the collector may grant opportunity of hearing to the petitioner as well as other concerned parties. Yes, item 30.
Item 30. Sir.
Sir, why you challenged after the period has expired? Why didn't you file immediately on 29th or 30th? Madam, how can he do it? Such a short time. Within 2 days, you wanted him to lift everything.
That's as per
I've seen there was an order of the High Court where it was extended. There is some order, interim order that permitting him to lift.
that the license was renewed, my lord. But with respect to the NGQ aspect, the shortfall of NGQ has to be.
I think there is some order permitting him to withdraw or draw, I mean the lift within a certain time.
Yes, my lord, the shop was closed on the 1st of April 2024.
That is what is, then you approach the High Court directed it, then they renewed it. Correct.
So now they have demanded the closure period MGQ.
Absolutely.
That and for that only my lord. And in the similar case, my lord has already directed
the extension of time to lift.
Not extension, no courses action, my lord.
So your license closed from 31st March.
We have deposited the money, but the shop is closed.
Shop is closed
because of non-lifting of the NGQ during the closure period.
Make a changes, give it to her.
I have only given a copy.
This is an applicable order order. Again, under section rule 250. Appeal can be made to.
We'll pass them also. Make necessary this.
Based on the judgment of this honorable court.
Show it to her. Give a changes disposed of on that basis.
Yes, madam.
Make a changes and disposed of. Date of the notice is different.
Yes, madam. I'll make necessary.
Please make the changes, sure.
Next also similar, madam. 31.
30 and 31.
31 same.
Yes. Madam, you are appearing in that matter also? 31?
I am appearing.
Look at it.
But the impugned notice is not annexed to the.
No, no.
Next month. Next annex. It is annex 4, I think.
No, madam. That is annexure 8.
No. In 31.
You may look at it where.
Anyhow, look into it. Is there? Yes, call the next 32.
Item 32.
Why contempt?
Contempt is actually, I want to throw a lawsuit attention to Annex 1. This honorable court was pleased to pass the order, that is page 13.
Annexure 1 is the notification.
Consider the objections of the aggrieved persons regarding the hike of the benchmark valuation to an astronomical scale. And in spite of thousands of objections and representations, they are also making several correspondences, intra-departmental correspondences.
They have not taken a decision.
You have not taken a decision. They are not taking a decision. They have sought for time.
Let me take instruction from you.
Mr. Das, then in the exist list on 13th May.
Item 33.
Same instruction.
Yes, item 33 also has the content. The order was fast communicated and
You want instructions, Mr. Das?
the municipality CD and CMC
Development authority
Have
and
you,
CMC.
have you,
They are
have you served the
decided by
notice?
notice is required to be.
Yes. Sir, issue notice.
Issue notice,
Let's take notice.
issue notice, blah, blah. 14th May.
Orders item 34.
Poor my lord.
Appeared through caveat correspondence, but not from the copy of the.
You'll have to serve the copy on the caveat on.
Yes, I'll give it on.
Your lordship.
Mr. Das, learned AGA is directed to sort a copy of the appeal memo to Learned Council for the, but you are not, so your power is not there.
No, no, he has filed a caveat.
No, his power.
You have filed a caveat.
No, no, he has, his power is.
Okay.
To Learned Council for the caveator.
Yes, ma'am.
List on 24th April.
Item number 35.
In 35 also, Manfred appeared from the copy of the appeal memorandum of appeal and limitation application.
Same.
A copy of the appeal memo along with the interim applications may be served on Mr. ROUTRAY, Learned Council for appearing for the respondent. List on 24th April.
Item 36.
Same, the condonation application is to be served. Very well. Application for condonation of delay is required to be served. Nobody is happy.
No one is appearing.
But you'll have to serve to the parties.
Certainly, I'll have to serve. Otherwise, if your lordship directs me, I can take notice on them.
Yes, please.
Take notice, issue notice, blah, blah. 15th May. 15 May.
Item 37.
37 also
Same condonation.
Same matter. 15/5.
Issue notice, blah, blah, 15 May.
Item number 38.
Delay of 20 days. Who is for the other side?
I have been instructed to enter appearance for the respondents.
Respondent means the.
Both the respondents. There are two respondents.
You are.
Yes. Instruction.
Have you received the copy?
No, I have not received the copy.
Please serve him a copy.
Ms. R. Naik for the appellant and Mr. Then right, Mr. A.N. Das, Senior Counsel, enters appearance for the respondent. For the respondents, a copy of the appeal memo along with the interim applications may be served on him within 3 days. List on 25th April. Along with
yes, obviously.
Mr. Sarkar.
We can't fight Bogalata.
And copy we served on Mr. Sarkar.
Yes.
Item 39.
There's a condonation of delay application.
Both.
That is what will
file our objection.
20 days.
I would normally not.
Now you are a senior counsel.
I would normally not.
So
I leave it to them. I leave it.
39.
Take notice.
There is a delay of 90 days.
Take notice.
Sir.
Ma'am, sir.
Yes.
Notice. Yes. Only one problem. Contempt is fixed to 8.
25th.
8. Contempt is fixed to 8 every month.
So why you took so much a longer time to do it? Go there in for my contempt court. Yes.
Issue notice on the question of limitation and admission both.
Item number 40.
In the condonation.
Non-appeals. No one appeals for the appellant. List on 16th May, 16th April.
Yes.
For admission, item 41.
Yes, Mr. Das, 41.
Yes, my lord.
There has been a delay of 100 days. Oh, there is a still delay. It is not mentioned.
You have been controlled your last official.
It has been condoned.
Yes, Your Lordship.
So it has to be heard.
It has to be heard.
What is the point?
Point, my lord.
Where is the impugned order?
Yes.
This is the 26/4, 2024 order.
My lord, it's Annexure 4, page 78.
Yes.
Annexure 4, page 78 is the impugned order. Ready, Mr. Das?
Can I pray, my lord, little bit taken up some of it? It is not arranged in a proper manner. My friend has meeting.
Say that. We were reading the
6 time. Based on 13th May. Next.
Item 4.
There, Lordship, can I pray on? Reading May. I'm sorry.
Item 42.
It is at the behest of you are challenging the provision of the statute. Ultra virus, you said.
Yes, Your Lordship.
Which one? Annexion 1.
Yes.
What is this Annexion 1? You are seeking this notification to be an ultra virus.
Yes, sir.
So then the AG is required to be served and heard. And this is issued. This is issued what?
OPID codes.
OPID.
It's the protection of interest of depositors.
Why you seek ultra virus? You can seek for quashing and the setting aside of this notification. But why ultra virus? Ultra virus relates to any statutory. This is not a statutory.
Yes, Your Lordship, but it goes beyond the statute. The wording.
That's true. That's contrary to or devotes the statute. So you can quash it. Then why you are challenging it? Why you do not want this? Why you say it cannot be economic offense?
Because the
Establishment of a special court.
That is the thing, Your Lordship. If it is an economic offense pertaining to the Act, Your Lordship, to the OPID Act, then it can be tried by the OPID Act. But here what is happening is the cases which are triable by the Court of Magistrate and do not have OPID offences involved, Your Lordship, those cases have also been transferred to the
So that is a different aspect, but that does not mean that the entire notification has to go.
That notification, by virtue of this notification,
Yes.
the entire case records have been transferred to the OPID court.
The case record has not been done. That's an action of the authority, not in consonance with notification. But you are challenging the notification.
Yes, Your Lordship, because this notification has to go. They are saying that any offense that is
Sir, that is what is there, that it says that with concurrence of this, do hereby designate the existing 4 numbers of the special courts
Yes, Your Lordship.
established under the Odisha Protection and Interest of the Depositors, that's the Act of 2011,
Yes,
and the Odisha Act 21 as a special courts
Yes, sir.
to try and dispose of the cases initiated by an economic offence wing
Yes, Your Lordship.
for the areas as specified in column 2.
That is what we are challenging, Your Lordship. Even if any case, the cases which have both the OPID Act, there is a specialized act, Your Lordship. The cases which.
Please identify that those cases which do not come within the ambit of these acts have been transferred. Then the question would be the action.
Your Lordship, the case that is in
It can't be. Yes, matter what it is.
The case.
Madam, give us some details.
Your Lordship, I have that in Annex 3, Your Lordship. The question that Your Lordship put that I have been convicted in a case, Your Lordship, where I have not been convicted under the case has not been charged or investigated under the OPID Act.
Then you'll have to challenge this order before the appropriate forum.
Challenge, Your Lordship.
Here, how can it be challenged here?
Your Lordship, I had approached this honorable court in a criminal revision, Your Lordship.
In that specific case?
Yes, Your Lordship, in that specific case.
So here you have come in a general.
Yes, Your Lordship. Why? Because in Annex 3, I was told that because of this notification, I cannot approach in the manner I had approached. And that is why I have to challenge the notification itself, Your Lordship.
So therefore, we need what is that you cite some cases that where you have cited one cases of yours, but cite some more cases where the economic offence wing is also sending cases not relating to OPID Act to the designated court.
The present case is one such case.
One such case you have given. It is relating to one case.
A counter has been filed in this matter, Madam.
Counter has been filed.
The copy.
The copy has to be served. You serve. It's better.
Ms. For the petitioner and Ms. Das, and ASC. It is the copy of the counter may be served on Ms. Mishra and counsel for the petitioner by within 3 days. List on.
Rejoinder be filed.
List on 12th May. The meantime, rejoinder, if any, shall be filed.
Yes.
Item 43.
Yes, sir.
It's not challenging. Cancellation of RC,
Cancellation of?
election certificate.
Oh, that's the already order in this regard. It is the same case covered.
Yeah, let's see.
it may not be covered. It is on the ground that contravention of any of the provision of the statute. It is for not non-filing of the return, Your Lordship. Your Lordship, it is since he has not cooperated in the audit proceeding, Your Lordship, because the audit under section 65 is to be conducted in the business premises of the dealer, Your Lordship.
Correct.
So at the time of issuance of notice as well as all the proceeding, he has not cooperated in that and he was upset. And when after conduct of audit, Your Lordship, when the statement is to be signed by his authorized person, it has been recorded but not signed. But what happened here? Admittedly, Your Lordship, my concession may not be recorded. In the so-called notice, only the provision has been recorded.
But nothing has been.
No detailed reason has been.
So it's a vague so-called notice. The vague.
Vague, Your Lordship. So what my respectful submission, Your Lordship, the same order may be passed. Your Lordship, let me comply all the conditions, Your Lordship. So for the filing of the returns and levies and penalties and tax.
You agree, sir? You agree?
And Your Lordship, same order, only so far as that one undertaking, let him cooperate in all these proceedings, Your Lordship, because every month counter.
17, 18 and 18, 19 audit is completed. So against the compliance audit, we have approached the Honorable Court, remand the matter, and there we have appeared.
Okay.
Everything.
At the same time, find the counter by narrating all these things.
Maybe at it. Likewise, the direction get the relief in the interest of the MD. It is have made clear that it is uniformly submitted by the councils that there will be a cooperation in an audit to be conducted for any subsequent years.
And let it comply.
Only thing is a cooperation, that's all. Nothing more than that.
And the same order to be passed.
Yes.
You can comply all the statutory.
Yes.
Carefully.